Antonia Cabarroguis is a registered nurse and midwife. She sustained physical injuries as a result of an accident when the jeepney, of which she was a passenger, hit another vehicle at a street corner. The injury caused permanent partial disability to her right forearm. To avoid court litigation, the Lesforo Vicente, the owner and operator of the jeepney, entered into a compromise agreement with Antonia Cabarrugis. The Lesforo Vicente obligated himself to pay Antonia Cabarrugis the sum of 2,500 pesos as actual and compensatory, exemplary, and moral damages. Vicente has only paid a total of 1,500 pesos, leaving an unpaid balance of 1,000 pesos. It was also stipulated in the agreement that should Vicente fail to complete payment within a period of 60 days, Vicente would pay an additional amount of 200 pesos as liquidated damages. As Vicente failed and refused to comply with his obligation, Antonia Cabarrugis brought suit against him. Citing Article 1226 of the new Civil Code, Vicente argued that in obligations with the penal clause, the penalty substitutes the indemnity for damages and payment of interest. Should Vicente pay the interest on the amount of the judgment from the date of the filing of the complaint? The court ruled in the affirmative. As a rule, if the obligation consists in a sum of money, the only damage a creditor may recover, if the debtor incurs in delay, is the payment of the interest agreed upon or the legal interest, unless the contrary is stipulated. However, the creditor may also claim other damages, such as moral or exemplary damages, in addition to interest, the award of which is left to the discretion of the court. In obligations with a penal clause, however, as provided in Article 1226 of the new Civil Code, the penalty shall substitute the indemnity for damages and the payment of interests. The exceptions to this rule are: number 1, when the contrary is stipulated, when the debtor refuses to pay the penalty imposed in the obligation, in which case the creditor is entitled to interest on the amount of the penalty, in accordance with Article 2209, and third, when the obligor is guilty of fraud in the fulfillment of the obligation. Applying the law, it is evident that no interest can be awarded on the principal obligation of Vicente, the penalty of 200 pesos agreed upon having taken the place of the payment of such interest and the indemnity for damages. No stipulation to the contrary was made, and while Vicente was sued for breach of the compromise agreement, the breach was not occasioned by fraud. The case, however, takes a different aspect with respect to the penalty attached to principal obligation. It has been held that in obligations for the payment of a sum of money, when a penalty is stipulated for default, both the principal obligation and the penalty can be demanded by the creditor. Vicente, having refused to pay when demand was made, Cabarrugis clearly is entitled to interest on the amount of the penalty. Article 2210 of the new Civil Code also provides that in the discretion of the court, interest may be allowed upon damages awarded for breach of contract. This interest is recoverable from the time of delay, that is, from the date of demand, either judicial or extrajudicial. There being no showing as to when demand for payment was made, Cabarrugis must be considered to have made such demand only from the filing of the complaint.